Hi guys, it's Kathy. I hope you're doing well. I started a tiny bit early today because I want to say something. I'm I'm trying extremely very hard not to say anything political. This is not political. I don't care what side it is. But and this will only take 1 second and then I'll play the videos. What's happening in El Salvador is not okay. No evidence. None. More evidence that they are not Venezuelan and they are not criminals. And they will never get to go home again. And the way they're treated is not okay. And we did that. And we continue to do that. How dare we do that? I wouldn't have been able to sleep anymore at night if I didn't speak out here. And I did. And it's just not okay. I don't know how. I don't know how any sane, rational person thinks this is okay. But okay, time to get don't punch nurses. And if you do, don't punch their boobies. God, never punch boobies. They're not to be punched. Maybe they look like punching bags. Maybe in a strange warped sense, they look like punching bags. They're not punching bags ever. I skipped all the beginning because it was boring.
Uh, Counsel, do you know of any benefit your client would have by taking this case to trial?
No, Your Honor.
With that, to count one in cause number 50 DO3 2410 F6 251, battery against a public safety official. How do you plead, guilty or not guilty, to this level 6 felony?
Guilty, Your Honor.
In count 2, same charge, battery against a public safety official as a level 6 felony. How do you plead, guilty or not guilty?
Guilty, Your Honor.
Thank you. Please raise your right hand. Do you solemnly swear on the penalties for perjury the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth?
I swear, Your Honor.
Thank you. State your name.
I am Jacob Back.
State, would you like to provide a factual basis to the court?
Sure, Your Honor. Mr. Back, were you in Marshall County on or about September 29th, 2024? Yes. And while you were in Marshall County, were you arrested? I was. And were you taken to the hospital? I believe so, yes. And while you were at the hospital, did you knowingly or intentionally touch Taylor Saloff, who was a police officer for Bremen, in a rude, insolent, or angry manner by biting his arm? Yes. And then while also at the hospital, do you remember knowingly or intentionally touching a nurse at the Bremen hospital? See, I was a little intoxicated that night, so I don't necessarily remember, but I'm also not saying that it didn't happen, if that should make sense. But did you punch the nurse in her left breast while she was engaged in her nursing duties? Yes, I believe so.
We'll ask for the probable cause affidavit to be to support the factual basis of if we can get the.
I agree on
Any
that.
objection with that, Miss?
No, Your Honor. I
Okay.
agree to that.
I would also ask that you just take judicial notice of that.
Okay. Any questions, counsel?
No questions, Your Honor. I would agree, not on the factual basis, but he doesn't necessarily
remember. I get it.
But he acknowledges that it
happened.
Said it happened. It happened.
Yeah.
Based on the evidence.
He doesn't have any objection to the court considering the probable cause affidavit.
Correct.
And with all that, his acknowledgement here in open court, as much as it was, and the affidavit, counsel, would you concede that
his acknowledgement in court was, yeah, I was drunk, maybe it happened, I guess it happened? That's not an acknowledgement.
They would both support the entry of judgment of conviction by the court?
I do, Your Honor.
Okay, with that, Court finds the defendant to be 23 years of age. He understands the nature of the charge against him to which he has pled guilty. He understands the possible sentences and the fines thereunder, that he understands his constitutional rights, that he's freely and voluntarily waived said rights, that the plea is accurate. There's factual basis for the defendant's pleas of guilty. Now, with respect to the sentencing provisions, I'd like to give both parties the opportunity to convince the court to accept the terms of the agreement before I make any decision on that.
You want me to go first?
Yes, please.
So basically, Your Honor, we believe the plea agreement is fair in this situation due to the following is, he took responsibility of all of this. He has no prior history, and immediately upon bonding out of jail, he checked himself into an inpatient rehabilitation center, completed that program, is now attending AA classes also, has re-enrolled back in college, and is employed full-time. So we believe that the offer and plea agreement is fair under the circumstances.
And he spent 16 days in jail.
Correct.
State.
I would concur with what Ms. Buells has outlined. It's his first offense. It's a typically elevated offer from a first offense, given the nature of the offenses than what the state would typically offer in this case. Mr. Back is accepting responsibility. I would say, I would note relatively quickly for a felony case, given that it's within 6 months of the incident occurring. So with all those factors, we'd ask that you accept the plea agreement.
Okay. Mr. Back, your turn.
So I host an AA group every Friday, and I've found this opportunity to change my life for the better. And so as of April 10th, I will be 6 months sober. And so I'm really grateful just to have the opportunity to turn my life around, whereas so many people that I have met and known that didn't get this chance to, or this sort of opportunity is the best way I can put it, to really fix my life. Because frankly, I've known plenty of people that have passed away in circumstances like these. And I've, with my degree in criminal justice that I'm working on, I've seen many cases where it has gone a lot worse for a lot of people. And so I'm just grateful, as I said. So thank you.
He punched a nurse.
Perfect. One small little thing I like to hear. Well, there's a couple, but first things first, you acknowledge that you committed the crime.
Yeah.
He did not.
There are two magic words that I like. Well, it's a contraction and a magic word that I like to hear. Could you guess what they might be?
And everybody in here already guessed. We all know what it is. But he's so worried about him. He's so focused on him.
I'm grateful.
I'm part as good.
Yeah.
What's the other one?
I'm not certain.
I do. You're right.
Starts with an S. Sober?
Sorry.
Yeah.
Sorry.
Sorry.
Sorry. Yeah.
I'm sorry.
I am sorry.
That's the key.
Yeah.
I apologize.
Yeah.
Right?
Right.
Yeah. If those two guys were sitting here, or those two people were sitting here in court today, what would you tell them?
I would tell them I'm sorry.
There you go. I'm those guys.
You would thank them. Thank you for giving me the opportunity to turn my life around. Now you wouldn't.
Okay. I'm those people that you punched or grabbed.
Yeah.
Hurt. That's why you're here.
Exactly.
Tell me how you feel about that.
I wish I had the opportunity to tell them, like,
I'm going to give you that opportunity, because while you're on probation, you're going to write them a letter.
Okay, sweet.
Okay.
But
I would normally have you have it done prior to all this.
Right.
Okay. And then I'd have you read it in open court. I won't be here, but I'm going to have you do it while you're on probation.
Right.
Write these guys a letter.
Yeah.
People a letter. And tell them what you're going to, just tell me right now.
Exactly. And
tell me.
They had experienced me at my, quite possibly one of the most lowest points of my life. So they didn't get to see me at my best. So what I would like to tell them is that what I did was completely unexcusable, but what it is not indicative of who I am as a person.
That's right.
Yeah.
This is not you. You don't want to be known like this.
Yeah. And that was a moment, but not who I am.
How about, for just a second, you stop turning it on yourself? You punched a nurse. Say you're sorry. It was a nurse.
As an individual, and so,
you're not going to let it hold you back, but you still want to make sure that, number one, that they understand that that you're sorry.
Yeah, exactly, and that
and forgive you, and that you respect law enforcement.
Yes, and I'm really thankful for their patience that they exercised that night, because as I said, I could have been tased or God knows what,
Right.
So, but yeah, it has been completely a life-changing experience for the better, and I've honestly never.
No one's trying to unduly punish you.
Yeah,
you have to make some changes in your life. Obviously, you've made some huge changes in your life. We hope that you're on the right path, and we're going to guide you along in that regard, because you're going to be under our watchful eye for some period of time on probation.
Yes, Your Honor.
Okay, Counsel, do you think he's a good candidate for probation?
I do, based on all the things that he did on his own before all of this. So yes, after the incident, but leading into it to make sure this doesn't happen again.
You're asking the court to accept the agreement?
I am, Your Honor. Thank you.
State?
I am also asking that.
All right.
Walter, I wish the court would say
With that, court is going to accept your pleas of guilty today.
Thank you, Your Honor.
And find that you did commit the crimes in count 1 of battery against a public safety official as a level 6 felony. In count 2, battery against a public safety official as a level 6 felony, under judgment of conviction.
So I don't agree with that. He bit a cop. He punched a nurse. I'm not saying people should be allowed to bite cops, but that's a level 6 felony. Punching a nurse is not a level 6 felony. No, it should be 3 minimum.
Accordingly. Now, pursuant to the, do you know of any legal reason why he shouldn't be sentenced today?
No, Your Honor.
Okay. With that, pursuant to the agreement, you are hereby sentenced to, on each case, concurrently, 730 days in the Indiana Department of Corrections, with credit, with 730 days suspended, served on probation with credit for the 16 days actually served, plus 16, I don't know if you get, 16 days good time credit. So
he won't get that on probation. That originally this plea called from community corrections and some jail time that we've taken out, so that sentence is irrelevant.
Okay,
but yeah,
so just 730
of probation.
All
Yes.
right.
Yeah.
$1 fine on each count, court costs as required. I don't know if you've got a cash bond posted to satisfy those requirements. Counseling assessment to follow recommendations, reporting into probation. As of today, these sentences are to run concurrent. You must receive treatment on successful completion. AM, is that misdemeanor?
Yes.
Oh, okay, I figured that. All right, I had to read a little bit further past. So at least there's something out there that you're going to have. This is over with. You're going to have to file a petition. It's not going to automatically occur, but with the filing of a petition to have the convictions treated as a misdemeanors as opposed to felonies. Do you understand that?
I understand, Your Honor.
This. Now, rules and regulations of probation, have they been read? And we're going to waive reading of those in open court.
Okay.
You're going to report into probation today. You're also, while on probation, the added term here for me accepting the agreement is to, within 30 days, write a letter to these 2 officers. And they may or may not accept it, but I assume they probably will. They've seen probably worse during the course of their professional, but they may appreciate the fact that you took the time to do it. So you got to write that letter. All right.
Write a
Anything
letter.
else, counsel?
No, Your Honor.
All right. State,
Yeah.
you are free to go and report into probation today, please.
They'll give you a card
Thank
to
you.
take over to probation, and you can actually
Why give him
talk to
jail
them
time?
about
Oh, yeah, he punched a nurse.
This is the case of the state of Ohio versus Julia Still, case number 23 CR 40934 and 24 CR 41725. Present before the court is Ms. Still, right?
Yes.
Presented by Ms. Carr. We have Ms. Hyde from the prosecutor's office. We're here today for a pretrial, but it's my understanding Ms. Still is going to be entering a plea of guilty, and we're going to set this matter for sentencing. Is that accurately stated?
Yes, Your Honor.
Ms. Still, how old are you?
I'll be 38 on the 31st.
How far did you go in school?
I have a GED.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, at this time,
Are you taking any medications?
no.
Are you a United States citizen?
I am.
You're going to be entering what we call a blind plea, what I call a blind plea to these charges. That means that there have been no promises about what the sentence is going to be in the case. We're going to do a PSI. We're going to come back here in about 6 to 8 weeks. I'm going to look at that PSI stands for pre-sentence investigation, and I'm going to look at that pre-sentence investigation and make a decision as to what the sentence is going to be. So I think you and I can agree that it would not be possible for anybody to have made you any promises about your sentence. Is that
Right.
true?
Yes.
Has anybody made any threats or representations to get you to plead guilty to this against your will?
No.
I have 2 sets of documents. They are each entitled change of plea and entry, and each of them have a signature on the second page above the line defendant. Are those your signatures?
Yes, sir.
Did you review these documents with your attorney before you signed them?
Yes.
Are you satisfied with the representation that you've received in the case?
Yes.
In the 24 case, you're going to enter a plea of guilty to 1 count of tampering with records, 1 count of grand theft. In the 23 case, you're going to be entering a plea of guilty to 1 count of identity fraud. Now, the most serious of these charges is a third-degree felony. That's punishable by up to 36 months in prison and a $10,000 fine. If I do send you to prison, it also is subject to an optional period of post-release control of up to 2 years. But I don't have to send you to prison. I can put you into my community control program. That's what most people think of as probation. That means I would give you rules to live by, and if you don't follow those rules, I can change them. I can make them tougher. I can extend the time that you're on community control up to 5 years. Might include time in the local jail or in some sort of treatment facility. Before we go any further, Ms. Still, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. But they can. You have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do,
Yes, sir.
Ms. Hyde?
Your Honor, if these cases had proceeded to trial, the state would have shown beyond a reasonable doubt with respect to the 2023 case that on or about December 6th of 2022, while this defendant Julia Still was in Franklin, Warren County, Ohio, she did, without the express or implied consent of the victim, used and possessed the victim's personal identifying information and held herself out as that person. That's a felony of the 5th degree. In the 2024 case, the state again would have shown beyond a reasonable doubt that with respect to counts 1 and 2, that they both occurred on December 6th of 2022, while this defendant with respect to count 1, it would have been at the Warren County Jail here in Warren County. With respect to count 2, it was at the Kettering ER in Franklin, Warren County, Ohio. In count 1, she did, knowing that she didn't have privilege to do so, did with purpose to defraud, and knowing that she was facilitating a fraud, she did falsify records that were being kept by the Warren County Jail by holding herself out as being the victim in this case and not as her true self. That's a felony of the 3rd degree. With respect to count 2, while she was at the Kettering ER in Franklin, Warren County, Ohio, she did with purpose to deprive the victim of services, did knowingly obtain and exerted control, or she actually obtained services by deception by holding herself out as Nicole Young. This is a felony of the 4th degree due to the fact that she was able to obtain medical services in the amount of $11,836.
My My sister would do that to me. Oh yeah. Oh yeah, she pretended to be someone else, and I hate when people do that.
48 cents that was billed on my chart to Ms. Young's Care Source Insurance.
Anything on those facts, Ms. Carr?
Nothing on the facts?
Ms. Still, did you hear those facts?
I did.
You admit that they are true.
Yes.
You understand the rights you're giving up by entering a plea?
Yes.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to do a level 2 pre-sentence investigation, also an evaluation to determine whether or not you're appropriate for a community-based corrections facility. We'll see everybody back here in about 6 to 8 weeks.
Thank you.
All right, that's all.
My sister would do that to me in a heartbeat, in a second. She just pretended she was the victim and then got medical care. If you're in jail, though, maybe I'm stupid, but if you're in jail, isn't medical care free? Isn't it free? You don't need health insurance if you're in jail, right? I don't know. This is America. You probably do. I wish I could use someone's medical insurance to get some medical work done. All right. What are we doing? How much time did I use? Okay, let's go to, you know what, guys? Let's just go to a small town court in Colorado. Now, this is a small town, from what I understand. And nothing crazy happens. It's just a small town court. I would take shoddy medical care right now if it was available.
Elizabeth Ford for the people.
And Your Honor, this is Max Holland on behalf of Mr. Baca, present and appearing out of custody and in person today for a motions hearing. Your Honor, as I informed the court earlier, I did file an omnibus trial and evidence motion. It just needs a written ruling. And then
At some point, we're going to get strong Middleton vibes here, guys.
I do have a motion to suppress statements that we will require testimony for today.
Okay. Are you the prosecutor, Ms. Clark?
Yes, ma'am. I am, Your Honor.
Okay. I'm going to call up your first witness.
Your Honor, the people are calling to the stand Sergeant Cantoria.
Solemnly swear under penalty of perjury to tell the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Please be seated. Go ahead.
Sergeant Cantoria, will you spell your name for the record, please?
Cantoria.
Thank you. How long have you been a law enforcement officer?
I've been on patrol for about 7.5 years,
How long have you worked for LASO or Las Vegas County Sheriff's Office?
about 10.5.
Okay. Talking about July 15th of 2024, were you on duty on that date?
Yes.
Hold on a minute. Mr. Dale, you guys are talking, I can't hear, so you can go someplace else. Thank you.
Sergeant Cantoria, on July 15th of 2024, were you on duty on that day?
Yes, I was.
Were you in uniform?
Yes.
Were you in a marked patrol car?
Yes.
What were your duties that day?
To patrol the county and enforce CRS throughout the county.
During the course of your duties on July 15th of 24, did you make contact with Mr. Baca?
I did.
Were you within the boundaries of the city of Trinidad, County of Los Animas when you made contact with Mr. Baca?
Yes.
Do you see him in court today?
Yes.
Will you describe an article of clothing?
He's wearing a black jacket.
Your Honor, I'd like the record to reflect that Sergeant Cantoria has identified Mr. Baca today.
So noted.
Sergeant Cantoria, where did you make contact with Mr. Baca?
I met him at his mother's house.
Okay. And why did you go there?
I received a call that there was a private property crash that may have involved alcohol.
Okay. And when you arrived at that home, what's his mom's name? Do you know?
I don't recall.
Is it
It's
Mary?
I believe it is Mary.
Okay. When you arrived at Mary Baca's home, what did you observe?
Immediately as I pulled up, I witnessed
Ah,
about 5 slats of the privacy fence knocked in and broken.
And can you describe, kind of set the stage there when you say privacy fence? Was it in front of where you were driving, on the side of it?
I would have been on the left-hand side as I pulled into the driveway.
Okay. And did the damage look new?
Yes.
So you arrived at Mrs. Baca's home, and then tell me what happened.
As I got out of my vehicle, as I said, I noticed the damage to the fence. I walked up and I spoke to who the reporting party was a David Baca.
Okay. Do you know his relationship to the defendant?
He's his brother.
Okay. So did you speak to David?
I did.
And tell me about that conversation.
Briefly, David just told me that his brother had been drinking and then drove into his mother's privacy fence.
So once you talked with David, then what did you do?
Then I walked up to John, who was
Yeah.
sitting at his truck, outside his truck, at the bed of his truck, to ask him some questions about what had happened.
I'm sorry, can I just clarify? Where was John sitting?
He was standing next to his pickup.
Standing next, okay.
Yes,
I thought you
sorry.
said sitting, okay. Go ahead.
On which side of the truck was he standing?
Would have been on the passenger side.
Okay. And were you there by yourself?
Yes.
Okay. Will you describe?
I knew if I played this tiny little town in Colorado, that Simple Auto would come in and give it to us, and they delivered. Thank you so much. It's like when I play Colorado Court and you come and chat, I get like inside information that no one else has.
Your conversation with Mr. Baca?
I walked up to Mr. Bach and I just asked him what happened. He said that he got a little drunk and drove into his mom's fence.
Did he say, well, strike that. Continue.
Exactly. That's how you talk to insurance
At that point, I asked him about how much he had to drink. And he said he had, I can't remember an exact amount, but he said he had some tequila and that he drove head on into his mother's fence.
Okay. Did you inquire, at that point, did it become a DUI investigation?
Yes.
Okay. Tell me the rest of that.
So I asked him if he'd be willing to do any kind of roadside maneuvers. He declined on that.
Do you remember exactly what he said to you?
I don't remember exactly what he said.
Okay. Not sure if it's in your report. So he declined, and then go on. What was the rest of the conversation?
The rest of the conversation was basically about he had hurt his hand. I addressed that with him.
How did you know that his hand was hurt?
It was in a cast.
Okay. So you asked him what had happened to his arm?
Yeah, I asked him what happened to his arm, and he said he had injured it prior to the accident.
Okay. What was your next question?
I believe I asked Mr. Baca. I honestly don't recall asking him too many more questions about what happened with the accident, other than when I walked up, he divulged to me that he had been drinking. I asked if he backed into the fence. He said no, he drove head on to the fence. And then I asked him about his registration and insurance and things like that.
Let's start with his registration. Did you ever see his registration?
No.
Did he look for it?
No.
What about his insurance card?
No, he never presented any insurance, nor did he look for any insurance.
Did you ask for his driver's license?
Yes, he said that he didn't have it on it.
Okay. Did you come to find out the status of his driver's license?
Yeah, so unfortunately, our NCIC was down because we were having some power outages, but I later did find out that his license was revoked for prior DUIs.
Okay. So after you finished that brief conversation with Mr. Baca, did you say anything else to him at that point?
No, I told him I was going to take some pictures of the damage and then I'd be back and we talk about express consent.
Okay. So then what did you do?
Once I took photos of the damage to the fence, damage to the vehicle. While I was doing that, John's brother David was actually inside the vehicle trying to find the registration, insurance, and I observed the driver door was left open, and I observed 2 bottles of tequila underneath the floorboard, underneath the pedals of the floorboard on the driver's side.
Did the bottles have anything in them?
No, they were empty.
Okay. Do you
Now we know why he hit the fence. He couldn't step on the brake.
remember, did you just say what the size of the bottle was?
Judge, I'm going to object to relevance. This is a motion to suppress statements, not physical evidence. I don't see the relevance to this line of questioning.
Response to the objection?
I'll move on.
Very good. Sustained.
So you told Mr. Baca you were going to take some pictures and then review Colorado Express consent,
Yes.
correct? Okay. Tell me about that. After you took the pictures.
After I took the pictures, me and him went over to my vehicle. Well, actually, prior to that, I asked, when I did ask him about doing the roadside maneuvers, he basically just said, no, just take me. And so at that point, we walked over to my vehicle. I put him in handcuffs. I did a quick pat search on him looking for the keys of the vehicle.
Tell me about the handcuff situation. How did you?
So because his hand was in kind of a soft cast, I wasn't comfortable trying to put 2 sets of cuffs or a set of cuff on both hands. So I cuffed his right hand, which was his uninjured hand, to his belt loop. And then I sat him in my vehicle and advised him of express consent, which he chose breath.
Okay. And then once he elected for a breath test, what did you do?
At that point, we left and drove over to the jail where we can conduct that breath test.
Okay. Do you remember what time you got to their home, to Mrs. Baca's home?
I don't remember an exact time, approximately a little after 5 o'clock.
Okay. If I told you 5:11 p.m. where your body camera started, does that sound familiar
Yes.
to you? Do you remember what time you
I feel like I can fix it. I feel like they should let me fix this fence. I feel like I can do it.
left for the jail?
I don't. If I had to guess, it was maybe 10 minutes after that, around 17:20-ish. Or
Okay.
5:20-ish, sorry.
So from 17:11 to 17:21, does that sound?
That sounds about right.
Okay. So the entire conversation in the driveway, your investigation was 10 minutes,
Yes.
and then you took him to the jail.
Yes.
Did you ever tell Mr. Okay. Before you took Mr. Baca to your vehicle to be handcuffed and Colorado Express consent advised, before that, did you ever give him any instructions to do anything?
No.
Did you make him stand in a specific place?
No. In fact, he stayed in the same spot from the time I pulled up to the time we left.
And what were you doing during that time? Were you standing right there with him the entire time?
No, he stayed standing at the bed of the truck while I walked around, talked to David, took pictures, and kind of did that part of my investigation.
And where was his pickup parked at the time that you got there?
It was parked further in the driveway, closer to his mother's house.
Okay. Did you tell him don't go in there?
No,
Did you restrict him in any way?
no,
Did you raise your voice to him ever?
no.
What was his demeanor?
He was calm. He was very cooperative.
Okay. You didn't draw your firearm?
No.
Hi, Mary.
I don't have any other questions, Your Honor.
Cross, Mr. Holman.
Thank you, Your Honor. Sergeant Cantori, you said that you arrived at Mr. Baca's mom's residence on the 15th of July around 5 in response to a call from the reporting party, David Baca. Isn't that right?
Yes.
And that David Baca had called with regard to an accident on private property that may have involved consuming alcohol and driving under the influence, right?
Yes.
So when you arrived at the property that day, you were already investigating a potential DUI on private property, correct?
Yeah.
And in fact, when you stepped out of the vehicle, the first thing you saw was a fence that had been damaged.
Yes.
And the first person you spoke to was Mr. David Baca, right?
Yes.
And you never asked Mr. David Baca if he saw the accident occur, did you?
No, I don't believe I did.
You didn't ask him how he knew that the accident was the result of drinking and driving, did you?
No.
But you did talk to him and heard from him that he suspected his brother John had been drinking and driving.
Mm-hmm. Yeah.
So, and you also asked him if he thought that his brother John would do roadside maneuvers, correct?
Yes.
So when you approached Mr. John Baca at his truck, you were already under the impression that he may have been involved in a drinking and driving related accident on private property.
Yes.
And it's fair to say that when you approached him and asked questions, you were asking those questions designed to figure out if Mr. Baca was involved in criminal activity.
Well, when I walked up, I only asked him one question.
So the question was, it's fair to say that the questions you were asking of Mr. Baca were designed to get him to communicate whether he was involved in criminal activity. Isn't that right?
The question I asked him was very vague and general. I didn't ask him any questions about drinking.
I understand. I'm not asking about the content. What I'm saying is it's fair to say, given what you had observed and what you understood to be happening on that property that day, that when you were asking him questions, you were trying to get information about a potential crime.
I mean, I guess if I had to lead into further questioning, then it would have been questions towards that.
So, for example, you didn't ask him whether he thought the weather was nice that day, right?
No.
You asked him what happened that day, right?
Yes.
And you were on the premises in response to a reporting party alleging a crime had occurred, correct?
Yes.
So it's fair to say when you're talking to Mr. Baca, you're not interested in anything other than whether he was involved in the crime as alleged, right?
Right.
Okay. When you spoke with Mr. Baca prior to speaking with him, did you read him his rights at any time?
No.
Did you read him his Miranda rights at any time during your entire interaction with Mr. Baca?
No.
You asked him what happened, correct?
Yes.
You said that he got a little drunk, right?
Yes.
He also said that he drove into his mom's fence.
Yes.
And you had said to him, you backed into your mom's fence, right?
Yes.
And he corrected you and said, actually, it was a front swipe.
Yes.
Okay. Did you ask at any time when this happened?
No.
Did you ask at any time in what order this happened?
I did not.
You were on his mother's private property at the time, right?
Yes.
And when you're having this conversation with him, it's fair to say you were kind of walking around the vehicle, but you were on the passenger side of the vehicle with Mr. Baca.
Yeah.
And Mr. Baca was kind of leaning on the side of the truck bed,
Yes.
maybe around the wheel well or something.
Yeah, approximately, maybe.
And that behind him and behind you was the house on the property, correct? The
Yes.
front porch, the front door.
Where was Mom?
Officer, did you ever find the keys to the vehicle?
No, I don't believe we ever did.
So they were not on Mr. Baca's person at the time?
No.
No further questions.
Any redirect?
I just have a couple of questions. Sergeant Cantoria, the beginning of your report says you were dispatched to Mrs. Baca's home for a private property crash, possibly involving driving under the influence.
Yes.
So when you were driving there, did you think it was a DUI investigation?
I
Oh, Miguel.
I had a pretty good idea that it possibly could turn in.
I have a feeling, Miguel. Oh, no! They're gone. Miguel, you made me break it. I have a feeling, Miguel, if you listen a little bit longer, you're gonna figure this one out.
To that.
Up to the point before Mr. Baca responded to your what happened question with, I got a
Mr.
little
Baca.
drunk and hit the fence.
Chewbacca, Mr. Baca, Chewbacca.
Was it more crash investigation or more DUI?
Originally, when I got there, it was crash as I observed the damage to the fence.
New hope.
I don't think I have any other questions.
Was he released from his subpoena?
Yes.
Thank you, Sergeant Cantoria. You're excused. Any other witnesses, Ms. Ford?
No, Your Honor.
Thank you.
Mr. Holland, any witnesses?
Thank you.
No, Your Honor.
Argument, Ms. Ford?
Your Honor, Sergeant Cantoria was conducting a crash investigation, a vehicle accident, as he's required to do pursuant to 42-4-1606. Before Miranda's invoked, there has to be both custody and interrogation. There was no, I would submit to the court, there wasn't any custody. Mr. Baca was just leaning against his pickup. He received no direction at all to do anything, go anywhere. It was
You got HRH. And you got Kingsley.
a courteous, calm conversation. Sergeant Cantoria testified that he was walking about, he was taking pictures, he stepped aside to talk with the defendant's brother, David. Mr. Baca could have gone anywhere. Sergeant Cantoria was on his own. The demeanor was very calm. The entire stop lasted 10 minutes from the time that Sergeant Cantoria appeared there to him taking Mr. Baca to the jail to do the breath test. He was asked very limited questions that are related to an accident investigation, and those are permissible. What happened? I see the fence is crashed into, so what happened? Was your truck damaged? Once Mr. Baca blurted out that he had been drinking and hit the fence, he was asked, how much did you have to drink? Will you do roadsides? What happened to your arm? Do you have your ID? What's your birthday? Do you have insurance and registration? Those are standard and permissible questions for an investigation of that kind. He did not need to be Mirandized prior to that. He was not in custody and he was not being interrogated. An investigatory stop can be justified for the purpose of dispelling an officer's reasonable or articulable suspicion that that person committed a crime, may not be more intrusive than is required, and the scope and character of the intrusion are reasonably related to its purpose. And that's exactly what happened in that 10 minutes. So I'm asking the court to deny the defense motion to suppress these statements.
Mr. Holland, argument?
Thank you, Your Honor. Firstly, Your Honor, this differs in a lot of critical ways from a police stop. This was not a stop. This was an investigation on private property, actually at the residence where my client was living at the time. And I think that the fact of the location being private property where he was residing, obviously there was a voluntary request onto that private property from someone who lived there, so it doesn't require some kind of search warrant. However, I think that there is this circumstance of being on private property affects the custody piece of Miranda, and we're really talking about Miranda here. Specifically, when Mr. Baca was interrogated in his mother's yard, the question was whether he would have felt deprived of action, to the degree associated with formal arrest per People versus Taylor in the Colorado Supreme Court from 2002. And again, the time, place, and purpose of this encounter, Sergeant Cantori was very candid that he was investigating a potential allegation of drinking and driving on private property when he arrived, that there was no time when he was on that property. Indeed, as he's pulling in, he notices a fence broken and assumes that it's related to criminal activity caused by Mr. Baca that happened that day. So there's really no time during the entire investigation where Sergeant Cantoria is not involved in attempting to get information about a crime that's occurred. And again, given the totality of the circumstances, my client was not free to leave. For one thing, the officer was asking him direct questions related to the allegations of a crime. For another thing, he was on private property. The only thing he could possibly do is walk into the house where the officer could have pursued and was allowed to pursue with permission of the family there. Mr. Baca was admittedly under the influence of substances at the time of the interrogation, to say nothing at all, obviously, of the allegations. And that did not allow him to get in a vehicle and drive away from the interaction. So again, this is not an investigatory stop. This is a very different circumstance. This is the police on private property where my client is residing, asking him pointed questions and essentially taking his time up with regard to the investigation. So because of that, he was not free to leave, and no reasonable person in his shoes would have thought he was. Additionally, Judge, this was an interrogation. And again, that's because Sergeant Cantoria's questions were directly related to and designed to get Mr. Baca to admit to culpability in the conduct. It's not just express questioning, but it's any words or actions on part of the police that officers should reasonably know are likely to elicit an incriminating response from the suspect. The fact that this question was kind of circumspect or vague in the context of having just spoken with Mr. Baca's brother in front of John, who's alleging directly in front of John that John was drunk and drove into the fence. In that context, that is an interrogation. Finally, Judge, in two parts. Firstly, we have an admission by Sergeant Cantoria that Mr. Baca was never read his Miranda rights as is required by Miranda versus Arizona. And that, again, if any statements are obtained without those warnings, those statements are subject to suppression. No law enforcement officer in this case ever completed those constitutionally required warnings and gave them to Mr. Baca. And so the statements he gave should be suppressed under the Fifth Amendment and Section 2, Article 2, Section 18 of the Colorado Constitution. Finally, Judge, Mr. Baca's statements were not voluntary. He could not voluntarily waive rights that he was never informed of. And so as a result, as well, of the failure of police in this instance to read Mr. Baca's his Miranda rights, he could not have voluntarily waived them. So our argument again is, Judge, that he was in custody. It was an interrogation, that he was not read his rights and that he did not waive his rights, and that the statements made to police on that day should be suppressed as a matter of law. Thank you.
Thank you, Mr. Holland. Any response, Ms. Ford?
Your Honor, I just want to reiterate to the court that as Sergeant Cantoria testified, when he approached Mr. Baca, he said, "What happened?" That's all he said. What happened? There had been an accident. And Mr. Baca volunteered all the information that related to him being drunk and hitting his mother's fence head on. I think the fact that they were on private property is makes it even less likely that he felt that he was being detained. He could have gone anywhere. Mr. Holland makes that point that he could have just gone into the house. Mr. Holland just said that. Although he added he would have been pursued by Sergeant Cantoria with permission of the family. Well, they never even got that far. It never even rose to that. The family called the sheriff to deal with Mr. Baca. And it's just a typical, I would call it a stop. Perhaps it's a contact is a more artful way of saying it. But I don't think that Sergeant Cantoria overreached beyond into a custodial interrogation. That simply didn't happen. It was a very brief and basic contact regarding what ended up being a drunk driving accident. And again, asking the court to deny the defense's motion. Okay, thank you. The testimony in front of the court is that Sergeant Cantoria was dispatched due to a crash. The reporting party was the brother of the accused defendant and was on the property of his mother. However, Mr. Holland argued that, I think that Mr. Holland said that his client, Mr. Baca, lived there, but then later in his argument said it was his mother's property. So I'm not sure about that, but that doesn't really play into the order that I'm going to issue. Sergeant Cantoria indicated that, or testified that he arrived, he said what happened, and Mr. Baca said, I got a little drunk and I ran into the fence, and Sergeant Cantoria said, how much did you have to drink? And he wasn't sure. He had tequila. Sergeant Cantoria testified that the entire encounter was maybe 10 minutes, that Mr. Baca was cooperative. It was a courteous conversation, and he declined roadsides, which he has an absolute legal right to do. And then Sergeant Cantoria advised him of the express consent, and he chose to take a breath test. Mr. Holland makes good arguments. However, the court disagrees, and your motion to suppress is denied. Now, you are set for trial on May 6th. I think we should probably have another pretrial conference before that date.
Yes, Your Honor, I would request one no later than 2 weeks, no sooner than 2 weeks before trial.
Okay. April 23rd. Does that work?
I believe I'm in trial that day, but I don't have any objection to keeping that date for now, Judge.
Okay. What time, Lisa? All right, April 23rd at 9:30, and we will alert Judge Fowler that you have filed the omnibus.
Thank you, Your Honor. I do appreciate that.
Okay. All right. We are in recess.
And I'm sorry, 9:30, Judge?
Yes.
Thank you.
I don't think you're allowed to drive drunk on
Mr. Holmes,
private
we don't.
property.
Oh, yes, we do have the Pueblo County Detention Center on. So let's call up Jose Ninawapa.
I kept this other one in because this is where it gets Judge Middleton.
Ms. Waddell, are you covering this advisement? Yes. Okay, great.
So remember when I played that case where the woman got a DUI because she's at her house. She's drinking at her house. And she's having a party with friends. And she had to move her car from the driveway so someone else could get out. So she backed her car out of the driveway and parked it on the road, just like that. And she got a DUI because she was driving drunk. And all she did was back her car out of the driveway. And she got a DUI for that.
Good afternoon.
Good morning.
Hello, this is Judge Gerbraw. It looks like I have Pueblo County Detention Center on WebEx. Is that correct? For Mr. Jose Ninawapa? Hello?
This is Judge Garbaraugh. Do I have Mr. Nina Wapa from the Pueblo County Detention Center on WebEx?
So far on this channel, you've seen a DUI from backing out of a driveway, 2 DUIs driving around Walmart in one of their carts, 2 DUIs from riding on a lawnmower. I feel like there was another weird DUI, but I can't, it's not hitting me.
Yes, Your Honor.
Okay, thank you. This is 25M41. Mr. Nina Wapa, this is Judge Garbaraugh. Can you hear me?
Your Honor.
Okay. You are, an affidavit for an arrest warrant was issued for you for assault in the 3rd degree. That's a class 1 misdemeanor that could carry up to 18 months in the Los Animas County Jail. You also have an open case in Huerfano County, 24 CR 94. The named victim is Jerome Ulabari. Mr. Nina Wapa, you have a right to remain silent. Anything you say may be held against you in further court proceedings. You have a right to enter a plea of not guilty and have a trial either to court or jury. Any plea you make must be voluntary, and you have a right to an attorney. Ms. Madeline Waddell is here for defense lawyer. Ms. Waddell, what would you like to tell the court?
Yes, Judge. So first, I just wanted to correct the record. I saw that on there, but that CR case is not Mr. Nina Wapa. That's his father.
Oh, okay. Thank you for that correction.
So it's my understanding this is his only open
A family that goes to jail together stays together.
case right now. I was not able to speak with Mr. Nina Wapa beforehand, but I do know him to be a longtime resident of the county. I have spoken with his mother many times. I know they have a place in Aguilar, and they also have a place in Walsenburg as well. So he does have strong ties to this community. I also know that he has not been able to post any bond in the past. I believe, I couldn't tell from the record, but I believe he's been in the Pueblo County Jail since the 14th. But
And I have access to the bus system too.
Okay, that's great. He has access to the bus system. So I think that will help him get back to court as well. And just based on the nature of the allegation here being a misdemeanor and a non-DUI case, we would be asking for a personal recognizance bond.
Go ahead.
Hello, I'm Madison Dowdy, by the way. I'm the new deputy DA.
Nice to meet you.
We would request a $1,500 cash surety bond. Mr. has a extensive criminal history. He has at least 2 felonies and 21 failures to appear. His address is listed as homeless. So I would be concerned about his ability to show up to court. And based on the bond schedule, this is an M1, so we request the $1,500 cash surety.
Anything else, Ms. Waddell? Anything else, Ms. Waddell?
I want to get out. I have medications and stuff. I wanted to get access to like my.
Okay, hold on. Mr. Nina Wapa, hold on 1 second, please.
Your Honor, I did just want to make sure those felonies listed were from Mr. Jose Nina Wapa Jr.
They were. I can give you the case numbers if you'd like.
Okay, that's
2016 or 2016 CR 47 Los Animas, and that's a trust.
That's my bad. So I thought at the end of that clip was where she was talking to the guy like Judge Middleton, but that must be on a separate clip. So we don't have it. But that's right. Let's go to hell court. Let's go to hell court for a little bit. I don't think anything crazy happens here. We just haven't been there in a while.
Sir, raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury the testimony that you provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead and have a seat, please. And please tell me your full name. Thank you. The court shows that the defendant appears in person and also with Attorney Teresa Keenan, the state of Indiana, appears by DPA Colin Gruber. And I show that we are set for further proceedings on a violation of probation. Ms. Seaman, what are we doing?
That's correct, Your Honor. And today, we would like to come back again to court, and we can do it in either 2 fashions, of course, whatever the court please. One would be that he would enter an admission of a relapse, but come back for disposition because he's got an appointment on the 21st with Counselor Matt Reese at Oakland, and we think that would shed some light on disposition. Also, he has some other information already about his residency at Oakland where he lives, and wanted to bring that. Also, he called last week on Friday and wanted an appointment. We couldn't schedule one. We have talked before and again this morning, but for those reasons, we wanted to come back. We can do that with entering an admission because he does intend to admit, or we can, and then set up for disposition, or we can come back and do it all at once. Whatever.
Mr. Groover, I don't know if you have a preference.
Your Honor, we did speak.
I think this lawyer needs to go over with herself again what it means when she says he plans on admitting. She needs to reevaluate her words.
About this previously, and the state is, I don't know that we have a preference either. I am fine going forward with an admission today and setting out for.
I tried everything I could to get that mic to work today, and it doesn't. It just doesn't. The microphone part doesn't work. I can hear barely, but I can't talk. But I got another one coming in today by 7 o'clock, and hopefully my microphone will be better tomorrow.
Sanctions.
I think that's fine.
Okay.
Okay. So, Mr. Holliday, do you understand what that means? So I'm hearing that you are going to admit today that you violated your placement on probation. However, we're going to come back later to determine sanctions based upon some information that your attorney is going to get from your counselor and also about your housing. Is that what you want to do today?
Yeah.
Okay. Mr. Holliday, do you understand what probation has said that you have done to violate your placement on that program?
Okay.
And do you understand that you are not required to admit that you violated your placement on probation and that you can instead require that the state of Indiana prove that you did so? So it's kind of like pleading guilty. You don't have to plead guilty. You can make state prove that you violated or prove that you committed offense. Same thing with probation. You don't have to admit. If you say, I didn't violate, then the state would have to prove that you violated your placement. Do you understand that that is a right that you have?
Yes.
Okay. Mr. Holliday, if you denied that you violated your placement on probation, we will have what's called an evidentiary hearing. And at that hearing, the state of Indiana presents evidence, which usually happens through the testimony of witnesses, like your probation officer. You would have the right to confront and cross-examine any witnesses called by the state of Indiana at that hearing. Do you understand that?
Yes.
Mr. Holliday, you also have the subpoena power of the court, which means that you can require that witnesses appear at that evidentiary hearing and testify on your behalf, and the exercise of that right does not cost you anything. Do you understand that?
Yes.
So you have the right to have an attorney represent you at that evidentiary hearing if you wanted to have that hearing. So that means that Ms. Heeman would represent you at that hearing. She would also help you with preparing for that hearing. Do you understand that?
Yes.
Mr. Holliday, do you understand that if I find that you violated your placement on probation, that I can revoke your placement on probation and order that you serve the balance of your suspended sentence?
Yeah.
And sir, with everything that we've talked about today, do you still want to admit that you violated your placement on probation?
No, I don't want to say I violated. I don't want to admit that I violated. She relapsed.
Well, and I mean, that's
because I went to move to Oakland, and the Oakland fell apart. And I relapsed, and because I was deformed, because I had to move to Oakland, I was in. So, like, same thing I told you last time. But I'm sorry it happened. I mean.
So, Mr. Holliday, and I understand what you're saying. I mean, saying that you're admitting you violated your placement on probation, that's kind of harsh, but by relapsing, that would be another way of admitting that you violated your placement. Okay? Do you understand that, Mr. Holliday?
No, I didn't understand.
No, I don't understand, Judge. You don't understand, Judge. I didn't violate my probation. I only did drugs. I didn't violate anything. I did drugs, Judge. Don't you get it, Judge?
But it's the same thing as me.
Correct.
Yeah, I did something. Yeah, it happened.
Okay.
Violation did happen. It was irresponsible.
Okay, so Ms. Seaman's going to ask follow-up questions on that. Go ahead, Ms. Seaman.
Thank you.
Good luck.
Let's talk about that a little bit, Princeton. Is it correct that you were sentenced back on June 7th, 2022 to a term that included probation of sentencing? You were put on probation, right? Yes. And then a violation was filed on January 9th, 2025, wherein it was alleged, as you said, that you relapsed. Is that correct? Yes. And in that violation notice, they alleged that you had submitted a drug screen on December 17th, 2024, and that screen came back positive for amphetamine/methamphetamine. Is that correct? Yes. And did you in fact use amphetamine or methamphetamine during the period of your probation?
Yes, I used amphetamine and methamphetamine. Yeah.
Then they say they got a call from Oaklawn that you had been involved with Oaklawn in their addiction evaluation program and also tested positive for methamphetamine. So again, do you acknowledge and admit that Oaklawn also got that positive test?
Yeah, I took like 3 tests at one time.
Okay, and were they positive for methamphetamine from that time period in December of 2024?
Oh, yeah.
Okay, and since then, are you involved with Oaklawn?
She almost sounds like Mrs. Potts, the driving instructor on SpongeBob?
I live in the Oaklawn, the estates in Oaklawn, and yeah. So I've been there for maybe going on 7 months, maybe 8 months, Bert.
And one of the things that you told me about was the fact that you have an appointment coming up on the 21st of this month with Counselor Matt Reese to continue working on counseling and therapy.
Yes, I went to a class. I've gotten to drug classes, and Matt Reese is my counselor, and he's going to be there. But I talk to him. I call him as much as when I need to, and I've only been to one class, So, but we have a meeting on the 21st. I call him, whenever I need to talk to him, I talk to him, or have a meeting with him. And I've had like 4 meetings with him. We have one more meeting, and that's on the 21st.
Okay, perfect. Thank you.
State, you have any questions on the factual basis?
No questions, Judge.
The court will find that the defendant has tendered a knowing voluntary admission based upon the factual basis. The court will find the defendant has violated the terms and conditions of his placement on probation by ingesting an illegal substance.
That ain't right, Judge.
So we need to set this out for sanctions.
Yes, please.
How far out?
Well, past the 21st, and then the other things that we were hoping to provide to the court would be some Oaklawn reports. Maybe that'll take 30 days. So in that neighborhood, please.
Okay, so it's the 21st of March that you're meeting with?
Is it March? The 21st, that's your appointment?
Yes.
Yes.
All right, so the date that I would be looking to come back after that would be on April 14th at 8:30?
Yes, please.
Mr. Holliday, are you still involved in Clubhouse? Good.
All the time.
I know, and Francis is a good dude, so. Do you disagree?
No, wait.
Okay, I thought you were disagreeing with me.
Yeah, he's cool.
Okay.
Okay.
Yes.
And this is my phone number right here. If you want to talk before, call that number and it's a phone. Personal. Thank you.
All right, thank you.
Okay.
Videos? Oh, was I supposed to put videos on?
Okay. This is cause number 20-12409C on 1616, Steve Indiana versus Thomas Keene. So raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury, the testimony that you provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Go ahead and have a seat, please.
It's amazing to see you.
Excuse me. Please tell me your full name.
Thomas Key.
Thank you. The court shows the defendant appears in person and also with Attorney Teresa Heeman, State of Indiana appears by DPA Colin Groover, and I show that you're set for sentencing. Ms. Heeman, are you prepared to make arguments on your client's behalf?
Yes, Your Honor.
You may do so.
Thank you, Your Honor. This is a case where there is no jail credit, and that's because defendant was summoned in order to appear, and he did. And so I think, again, that is a good sign that supports the plea terms for probation. Also, we wanted you to know that he did take the events very seriously, and he's gotten involved in substance abuse programs. On December 3rd of 2024, we filed certificate of completion of substance abuse programs that he had completed. And then again, on February 25th, we filed the Pinnacle treatment letter to show that he had continued and completed Pinnacle treatment. So we wanted you to know that, just to let you know, Your Honor, again, that he has taken steps to better himself, to address any issues that arose because of this crime. And we also wanted you to know that part of the reason I think that this was sentenced as it was because of...
Look at it. It's like, this is why I call it hell court. It's like she's here, but then everything else is just sucked into blackness around her. So it's like nothing but black and a judge sitting right in front of you. Hell court.
Lack of any significant prior criminal history, and I think a letter from the victim, Kayla Key. And that letter was sent to the state, and I think that helped inform them about the situation. Thank you.
Thank you. Mr. Keene, is there anything you would like to say on your own behalf?
Yes, Your Honor. I'm very sorry for the argument we got into. Me and my ex-wife co-parent very well, and we're very great friends. Got into a pretty bad argument, and it went the wrong way fast, and I'm just very sorry. I know it won't happen again. We still talk to each other every day, I see my kids every day, so that lets you know that.
All right, thank you. Arguments from the state, please.
Thank you, Your Honor. In looking at Mr. Keene's criminal history, I guess I would agree in part. There is some substantial criminal history, although it is further removed. It's further back in time from what I can see. And the bulk of what I do see is mostly substance abuse related. And so, you know, this, with regard to recent offenses, this does kind of stand out as I guess atypical for Mr. Keene, and so I do believe that the sentence that has been agreed to is appropriate, and the state would ask that the court accept the agreement.
All right, thank you. Based upon the information provided, the court will accept the defendant's plea agreement and sentence him according to the terms of the plea agreement on the charge of domestic battery as a Class A misdemeanor. The court will sentence the defendant to 1 year at Gilchrist County. Yes, 1 year at Gilchrist County Correctional Facility. There is no credit to award against that sentence.
That was last year. This year, I know.
However, it looks like pursuant to the terms of the plea agreement, that sentence is suspended on 180 days of probation, with the level of probation supervision to be determined by the probation department. Mr. Keene, I will also order that you participate in any programming or treatment that probation believes will benefit you over the course of your supervision. Mr. Gruber, would it be fair to say that there is no request for a no contact order?
That's correct, Your Honor.
Okay, the court will decline to impose a no contact order. If there was a pretrial no contact order, it is dismissed. The court will make a domestic violence determination. And Mr. Keene, what that means for you is that you are prohibited from possessing firearms and ammunition. It means that you may also have restrictions in parenting time with minor children. Do you understand that?
Understand the parenting time.
Let me explain it to you. Hopefully I can explain it in a way that makes sense. So Mr. Keene, it's not something that is triggered automatically. If you and your ex-wife go back to court, if there's a disagreement about your parenting time or the custody, one of the factors that the court has to consider in making its decision to change any parenting time or custody would be if one of the parents had a conviction for a crime involving domestic violence. So, and even in that instance, it's also not automatic. It's just a factor that the court has to consider. Does that make sense?
Yes.
Okay. The court will order that you pay the mandatory court costs, which includes the $50 domestic violence fee. Mr. Keene, is it safe to say that you're working?
Yeah, I started this week.
Okay, where?
I started last week.
Okay, where are you working?
Forest River.
Okay. And probably not on piece rate yet. How much are you making an hour there?
17.
Okay. Do you have to pay child support? How long has it been since you've been working?
I just started Monday last week.
I guess I should say, how long has it been in between jobs?
7 or 8 months, maybe 9.
Okay, so you're out of work for that long?
Yeah.
All right, the court will impose the mandatory court costs only. No additional court costs will be imposed. I will show that the appearance of the public defender's office is withdrawn. Any future hearing dates?
How though? Okay, maybe unless you're like selling drugs or something, how do you go 6 months without any income? No money coming in. I can't. If I missed 1 week of work, I would be screwed. I would be so screwed. Oh man. Look, see that right here? This poor judge is getting 1 viewer, and that's us. She deserves more.
The vacated judgment of conviction is entered on domestic battery as a Class A misdemeanor. And as we've already stated, there was no bond that was posted. It was a summons. All right, Mr. Keene, you will need to take this piece of paper that is about to be handed to you up to the probation department so that you can sign the terms of your placement on probation. Do you know where the probation department is located?
Yes, I believe so.
Yep.
I live in South Bend, and I don't know if I talked to you, is there any way I can get this transferred to there?
Ms. Heeman, if you would take on that form at the bottom where it says transfer, if you would change that to St. Joseph County, Indiana. Where it says transfer, it's probation.
I see it now.
So if you just, yeah, that's not a problem, Mr. Keene.
Thank you.
So the court, at the request of the defendant, will authorize the transfer of his probation to St. Joseph County, Indiana. Anything else, Ms. Heeman?
Nothing further.
Anything further from the state?
No, Your Honor.
Okay, so you'll have to start that process here, and since it's on the form, they'll already know about that, and they'll tell you what you need to do.
Okay.
All right, thank you.
Thank you.
Thank you.
Thank
This is cause number 20-012410CM1731, State of Indiana versus Samuel Smallwood.
I don't know what happens here because I fell asleep and kept recording because I was asleep. And I wake up in like 20 minutes. So I'm trying to figure out if I want to keep playing or if I want to go to Judge Fleischer. And of course, the correct decision would be go to Judge Fleischer. So obviously, I'm going to keep playing.
So raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury the testimony that you provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please tell me your full name. Thank you. The court shows the defendant appears in person and also with Attorney Teresa Heeman. State of Indiana appears by DPA Colin Gruber. And I show that we are set for sentencing. Ms. Heeman, are you prepared to make arguments on your client's behalf?
Yes, Your Honor.
You may do so.
Thank you, Your Honor. Your Honor, we had a credit time memo come through with 29 actual days credit. We agree that's correct, and also would bring that up as a point to be considered and that Samuel had to serve that as part of this consequence. And so we think that that also makes the plea agreement terms all the more appropriate. He also, as you know, has a sentence that we couldn't transfer over from city court that is going to run consecutively and is also acknowledged in this plea agreement. He's entered that sentence and been sentenced. Start tomorrow? Okay. So we're asking you to complete the kind of a global plea, albeit not in the same court, and accept these terms as well. Thank you.
Thank you. Mr. Smallwood, is there anything that you'd like to say on your own behalf? Thank you. Arguments from the state.
Thank you, Your Honor. In looking at Mr. Smallwood's history, there's not a significant, I guess, record of convictions, although the state is concerned with, the amount of cases, I guess, that have been brought kind of involving a similar fact pattern. There is, as Ms. Heeman indicated, he was just recently sentenced on another battery case out of Elkhart City Court, and the sentence that is imposed here will have to be consecutive to that. That being said, with regard to his criminal convictions, there's just simply not a lot. And so I do think that this is an appropriate plea agreement, and I would ask the court accept.
Thank you, Mr. Groover. Based upon the court's review of the information and the representations of counsel, this is an appropriate plea agreement. The court will accept the plea agreement and sentence the defendant according to the terms of the plea agreement. On count 2, invasion of privacy is a Class A misdemeanor. The court will sentence the defendant to 180 days at the Elkhart County Correctional Facility. The court will award the defendant credit for 29 days served plus equal good time credit, and I will suspend the remaining portion of that sentence on probation at a level of probation supervision deemed appropriate by the probation department. Mr. Smallwood, I will order that you participate in any programming or treatment that probation believes will benefit you over the course of your supervision on probation. I will also show that the sentence is to be served consecutively with cause number 20H01-2310CN5796. Mr. Groover, is the state requesting a no contact order?
No, Your Honor.
Well, that was pre-trial, so I'm just asking if they want that to be part of the sentence. And Mr. Groover is saying no, so I will not put a no contact order in place, and that one that was in place, I will show that that is dismissed. I will order that.
He just turned his head, and it looks like it's shaved on that side too, but like way down here. So, hold on. I'm going to try to show you what I think I saw. There's his head, okay? It looks like it's sort of like this with hair. This is all shaved, and this is all shaved. It's not I wouldn't say it's a mohawk because it doesn't go straight down the center. It like is just this part right here that has hair, and then everything else is shaved. Did you understand this picture right here? Hair, no hair. It absolutely is Microsoft Paint. I will use Microsoft Paint until they pry it from my hands. Yes, I will. No one can stop me. I have it on my computer. Even if they make it obsolete, they're not going to uninstall it from my computer.
You paid the mandatory court costs. Mr. Smallwood, are you working?
Yeah, 25 months.
Okay, is that all the income that you get? Okay, the court will impose the mandatory court costs only. No additional court costs will be imposed. I will show that the appearance of the public defender's office is withdrawn. Was there a bond? Yeah, there was a surety bond. I will show that the surety bond that was posted is released. I will show that any future hearing dates are vacated. Judgment of conviction is entered on count 2, invasion of privacy, as a Class A misdemeanor. Count 1 is dismissed pursuant to the terms of the plea agreement. Mr. Smallwood, I am going to go ahead and have you go up to probation now to sign the terms of your placement on probation, but you wouldn't actually start reporting to that probation until after you complete city probation. Do you know where this probation department is located? Yeah, and there's an elevator that's around the corner from the ramp. Anything further, Ms. Heenan?
No, Your Honor. Thank you.
Thank you. Anything further from the state?
No, Your Honor.
Thank you. That will conclude the proceedings. Thank you.
Michael. Hey, Michael. I got a laser pointer in today. I purchased. And it is amazing. It is so good. It's so nostalgic. Because when you flip it, it has different images, pretty much of the same thing. And I'm like, oh yeah, that's just like Jim. Oh yeah, that was just like Chris's. Oh yeah, I can actually put a name to each view of my laser pointer. So, guys, there is actually a laser pointer. Laser pointer is what I was trying to say, but I was that is different images of what I was just trying to draw there. So you just flip a little thing and there's a big one, there's a little one, there's a thin one, there's a fat one. It's so good. It is really so good. You all should get one. There's probably a link somewhere in Discord. I don't know. Or just Google it. Google's your friend. Okay. Oh, I got it, Fozzie, and it's delightful. I haven't actually had my cat chase it yet. I'm not. There's two ends to it. One end is the pictures, and the other end is just a straight laser pointer. I will have my cats for the straight laser pointer, but not, I just can't. I feel like I shouldn't get my cats to chase little tiny, wee-wees all over the place.
He was advised that he was being placed under arrest and needed to exit the vehicle. The defendant refused to exit the vehicle and stated the officers would have to break the glass to remove him. Officers made entry into the defendant's vehicle and placed the defendant in custody.
By chance, you know how fast? Does he say? Because he says a high rate of speed so fast that the car shakes.
Yes, and that's...
We know that it frustrates them, so we always land it on a toy or on a little pile of treats. We never just make them chase something for an hour for no... Although, they deserve to be frustrated, but no. I always land it in the end on a toy or a pile of treats or something.
All they have in the dim summary, Your Honor, and then it's him running the red light, causing people with the green light having to slam on their brakes.
Okay. Mr. Flores, I'm going to find that there's sufficient probable cause to go forward.
I plan on taking it out at night and only aiming it at the back of those big trucks that overcompensate. With a little teeny one.
42 case. Can you run his license, please?
Yes. His driver's license is eligible, Your Honor.
I'm ordering you as a condition of your bond not to drive in this manner again. If I see you drive like a complete maniacal person, I'm going to take your privilege drive away, and then I'm going to put you in jail. Do you understand? I will protect my street at all costs. If that means putting you in there with an extremely high bond, I'll do it in a heartbeat. No reckless driving, street takeovers, donuts, anything of this nature. Do you understand? You are also not allowed to drive unless you have valid liability insurance in your name as well. All of these are your bond conditions. We'll have you sign these bond conditions now. You pick up a new case if I find out anything. Do you understand? Now, because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with counsel. If he tells me he can't get a hold of you, you pick up a new case, you act like a bonehead. It's not going to go well for you. Do you understand? All right, I'll have you sign a reset with Victoria. We'll have you meet and take a seat in the jury box when we get your bond conditions. We'll have you sign it, and then you'll be free to go. Thank you, Your Honor. So do you mind filing those conditions?
I accidentally left the mouse on the next tab, and I'm sorry.
Yeah.
55528. Lundy, come on up.
Morning, Your Honor.
That way.
Hello. Good morning. Top of the, it's Friday Eve.
Yes, happy Friday.
Did you get it? The cost number?
Yes, I did.
Okay. Good morning, Mr. Lundy. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 12th, 2025, at approximately 4:45 p.m., an officer was dispatched to an FSGI call. Upon arrival, the officer spoke to the complainant, who stated he was traveling north on FM when a vehicle crashed into his vehicle. The driver then fled the scene without exchanging information. Complaining witness to the passenger stated that they were rear-ended, causing the defendant's vehicle to crash into a ditch. Defendant then approached them to check on their welfare, and once he saw they were unharmed, the defendant fled the scene on foot. The officer observed significant rear-end damage to the complainant's vehicle. The complainant provided a description of the defendant, and the officer ran the license plate and found the registered owners were Michael Lundy and Dylan Lundy. On March 13th, 2025, the officer received a call from Dylan Lundy, who wished to provide a voluntary statement regarding the incident. The defendant admitted to crashing into the complainant's vehicle and to fleeing on foot because he believed he had an open warrant for failure to appear for a window tint violation. The complainant positively identified the defendant by photograph. The estimated cost to repair was over $200, as the complainant believed their vehicle was totaled.
Okay. Can you run his license, please? And does he have any open cases anywhere? You can run an NCIC.
His driver's license is eligible, and I normally don't take note of Class C violations, but I do.
No, I don't care about Class C.
Right.
No, I don't care.
He does not have any open cases at the moment.
Got it. All right, Mr. Lundy, I'm going to find there's sufficient probable cause to go forward with the case. The only condition I'm placing on you now is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you may not drive. You understand?
Yes, sir.
Okay, I will waive your appearance because you have a lawyer. Just stay in contact with Will. He'll tell you if and when you have to come back to court. I'll have you sign a receipt, Victoria. We'll have you take a seat while we get your conditions. You'll sign it and then you'll be free to go.
Thank you, Judge.
Don't pick up any new case.
Yes, sir.
Is that pre-trial bond conditions?
State's conditions.
Okay.
Okay,
Next
so-
on page 12. Howard, come on up.
Can you file those, please?
Yeah.
Good morning, Your Honor.
Hi. How are you, man?
I'm doing good, Judge. How are you?
Good.
Good.
What was the last name?
Howard.
Okay.
Page 12.
There we go. Right. Good morning, Ms. Howard. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have a right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
On March 16th, 2025, an officer observed a vehicle driving the wrong way on Durham Drive in Harris County, Texas. The officer asked the defendant to step out of the vehicle. The officer observed the defendant to have bloodshot eyes and the moderate odor of alcohol emitting from her. The defendant stated she was coming from Clutch Bar and had one shot. The defendant stated her GPS told her to go the wrong way. SFSTs were conducted. 4 out of 6 clues were observed on the HGN. 3 out of 8 clues observed on the walk and turn, and 1 out of 4 clues observed on the one-leg stand. The DIC was read, and the defendant consented to providing a breath sample. The results were 0.119 and 0.123.
Okay, Ms. Howard, I'm going to find that there's sufficient probable cause to go forward with your case. Do you mind running to see if she has any priority to be licensed, please?
Yes, Judge.
And a license?
She does not, and her driver's license is eligible.
Okay. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You understand, ma'am? You have a lawyer. He'll help you out. Just stay out of trouble. Don't pick up any new cases. If your license does get suspended, you may not drive, and Con will keep you in the loop. For now, I'll have you sign a receipt with Victoria. We'll have you get your conditions with Felicia, and then you're free to go. Thanks, guys.
Thank you, Your Honor.
Have fun. Good to see you.
Good to see you too, Judge.
Page 16. Phillips, come on up.
Morning, Judge.
Hi. You say 16?
Good.
Okay.
Phillips.
Good morning, Mr. Phillips.
Good morning, Your Honor.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On March 12th, 2025, at approximately 9:25 a.m., an officer was conducting a stationary traffic enforcement on a public roadway of the 7,000th block of IH 610 southbound in Harris County, Texas. The officer observed a red Ford pickup truck traveling at a high rate of speed with heavy traffic at the posted.
I think they should have Victoria read all of those. I think Victoria should read everything.
And the posted limit was 60 miles per hour. The officer witnessed the pickup truck bypassing other motor vehicles, weaving in and out of traffic at high speeds and coming dangerously close to other motor vehicles, with other drivers having to brake to avoid collisions as the Ford cut in front of them recklessly. The officer witnessed the pickup make multiple unsafe lane changes. A traffic stop was initiated. The officer reached speeds up to 110 miles per hour to catch up with the truck, but the pickup continued to distance itself from the patrol vehicle. The officer made contact with the defendant, driver, and sole occupant. The defendant admitted, "I know I was driving like an idiot. I just got off work." The defendant acknowledged he was aware that he could have caused an accident and hurt someone.
Mr. Phillips, I'm going to find that there's sufficient probable cause to go forward with the case. If I find that you drive like this again, it's really not going to go well for you. Do you understand?
Yes, sir.
I will protect my street at all costs. If that means putting you in jail with a $500,000 bond, I'm going to do it in a second. Do you understand?
Yes, sir.
Any more, I will also take your privilege to drive away from you as well. Can you look to see if he has a license?
Yes, his driver's license is eligible, Your Honor.
You are not allowed to drive unless you have valid liability insurance in your name, and that is also now a condition of your bond. No reckless driving, maniacally driving, donuts, street takeovers, anything of this nature. Do you understand?
Yes, Your Honor.
You will sign conditions to this, and after that, you'll be free to go. You have a lawyer, I will waive your appearance. Just keep my street safe, man. Every day we have people dying. It's not fair. Do you understand?
Yes, Your Honor.
Okay, come on.
Thank you, Judge.
Right this way. All right, Judge, next is page 1, Al Bardon. Come on up. All right, house made 20-27. And then it's numbers.
Make it work right there. Stand right here in the middle. I'm the judge.
All right, go ahead and have some.
Yes, sir. Thank you.
You can call Flores up now if you want to sign conditions as well. Sign this. What page did you say?
Page 1, top of page 1.
You were Mr. Al-Bardon? Sir, you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Thomas Flores?
On March 12th, 2025, an officer responded to a weapons disturbance call at a residence in Katy, Harris County, Texas. Upon arrival, the officer met with the witness, who stated the defendant, her brother, and the complainant, her sister, were inside the residence and were involved in a verbal disturbance. The witness believed the defendant walked upstairs to retrieve a firearm during the altercation, which caused her to walk out of the residence and call 911. The witness, the complainant, and the defendant were eating at the dinner table, and the defendant told the complainant that he will shoot the complainant and the complainant will need to leave the residence. The complainant stated that she lives at the residence with the defendant. The complainant stated the defendant got into a verbal altercation with their father, and the defendant stated that he was the man of the house. The defendant attempted to slap the complainant in her face, and the complainant moved her head back, causing her hijab to fall off her head. The defendant told the complainant he would grab a gun, hold her down, and shoot her. The defendant would see that the complainant would not be in the residence. The complainant stated she felt in fear when the defendant threatened to shoot her.
Mr. Al-Bardon, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case that identifies Ms. Lubna as a protected individual. Get to know this protective order, because if you do something to violate it, the state can and will file a violation of a protective order against you. And it's one of the worst cases that you can pick up. Do you understand? One of the things is this comes with a residential restriction that you're not allowed within 200 feet of the Park Fair Courthouse. Do you understand? If you go back to this place, it's not going to go well for you. Do you understand? How old are you, sir? How much? 33. Do you work? Do you have the ability to hire a lawyer? So what I'll do is I'll have you fill out an application for me. I need to know whether you can qualify for a court-appointed lawyer. Any allegation of alcohol or McKinsey? McKinsey, any alcohol or any dope or anything like
No
that?
allegations of alcohol.
Okay. So for now, what I'm going to do is I'm also ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand? I'll provide you a lawyer today and we can talk about how we go forward, but just be careful. I don't want to have to put you in jail. Do you understand? Okay. Do you mind giving me an application? Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. Do you have the RIP done?
Yes, I did speak to the complainant.
So what do they want?
They did not ask for no contact. My position that there should at least be some sort of cooling off period after something like this. Even though
Are they okay with having contact or no?
Yes, they would be okay with having contact.
Where's he going to go? Do they know?
Yeah, that's true.
Because he's not working. Where is he going to go?
Right. And I spoke to both the witness and the complainant, and both of them would be okay with him going back to the road.
Okay, so let's get him a lawyer and then we'll figure it out. Okay. Definitely no weapons, you know?
Definitely no weapons. We'll talk about it.
Yeah, okay.
All right, guys. I'm going to stop it here. I am really not feeling too good, and I'm going to go lay down. Which you guys could also do right now, too, because, oh, I don't feel good. All right. Thank you so much for coming out. I'm not doing OJ today. I'm going to go lay down. I hope you guys have a great, 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 great Friday. Tomorrow's Saturday, which sucks because I'm not going to stream tomorrow. I'm trying to stick to it, but it's hard, guys. I'll see you guys Sunday. Try not to get arrested today or tomorrow because, you know, judges don't work on weekends, but they do. Bye, guys. Have a great, great, great day. Thank you.
Crowd. feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's life.